which happened June 28th of 2020. There was originally a $10,000 bond. And then in 2020 CR 351, those offenses, charge of rape, occurred July 4th of 2020. He was given a $50,000 bond. While out on the $10,000 and the $50,000 bond, he was then charged in 2021 CR 59 with vandalism occurring on December 1st of 2020, was given another $50,000 bond, which he made. While out on $110,000 bond on the 3 cases aggregate, he was then charged with aggravated burglary and rape occurring June the 6th of 2021, and was again released on another $50,000 bond. So at the point that I filed this bond motion, he had an aggregate bond on the Dixon County cases of $160,000. Judge, I would like to bring to the court's attention that the defendant has previously been convicted of FTA. I have certified copies of that, which the defense has had an opportunity to review. That conviction was in 2018 and was from an offense in 2017. Additionally, while not included in my original bond motion, while out on bond, the defendant was convicted of multiple offenses in general sessions and served an 1129 sentence. So there are offenses from June 18th of 2021, where the defendant was convicted of false imprisonment and was given 1129 to serve. That conviction was on 7/7 of 2021. He was also convicted of reckless endangerment to run concurrently. I'll pass those up. Those are certified copies from Ms. Shelton.
Just have them marked along with this one, if you will. Officer, if you'll just turn your microphone on there, sir.
I'd like to, before those are entered as evidence, reserve objections to those, but I wanted to allow Ms. Bryson just to present with her argument. I think it'll make this move faster.
We're going to mark them, and whether or not they are admitted as evidence or not, I will consider your argument at that point.
Thank you.
Okay. I have another conviction from offenses on July 31st of 2020, where Mr. Godwin was also convicted that same day, July the 7th of 2021, and pled to criminal trespass. That sentence also ran concurrently, as well as assault, simple assault. Those are also certified copies. Judge, this case was continued because the state late filed a notice of impeachment and range of punishment, and I'd like the judge to consider the defendant's criminal history when determining, should you reinstate a bond? Should it be the same bond, or is that bond high enough considering the fact that he continues to get new offenses and has shown himself through his criminal convictions to be a danger to the public? Judge, his criminal history, most of those offenses start in 2007, and he has been convicted of robbery, aggravated burglary, another robbery, aggravated kidnapping, theft of property, especially aggravated burglary, another aggravated robbery, another aggravated kidnapping, and carjacking. And so we have a man with a demonstrated history of being a danger to the public who has 4 stacked up cases right now trying to be tried in front of this court, who continues while he's on bond to commit new offenses. Should the court choose to reinstate the bond because of the state's late filed notice, it is abundantly clear that $160,000 is just not sufficient. And so I would ask the judge to set a bond commensurate with the danger to the public.
Mr. Spratt, you wish to respond?
Yes, sir. Your Honor, as the court is well aware, this hearing was held in February, and the evidence solely put before the court at the Bergens hearing was the Lawrence County conviction. Or, I'm sorry, the Lawrence County charge. That suppression motion, my understanding is that the suppression was filed before the officer passed. The officer did pass, but there were identity problems as to whether or not that actually was Mr. Godwin. Those issues never got to be argued. As I said yesterday, we did not have the opportunity for cross-examination at the court's Bergens hearing in February. With respect to some of these cases were direct presentments, so I don't know the bond order. But the problem I've got with all of this is we're re-arguing things that, again, this procedure runs afoul of the due process considerations in Bergens. He's not got to cross-examine a witness yet, period, in any of this. And now the state presented evidence to the court over objection that we won't get to cross-examine ever. And now they're coming back and trying to re-argue. I understand what Ms. Bryson is saying, but with respect to those Sessions convictions that she just put up there, the reason I walked in a couple of minutes late yesterday is because I was on the phone with Mr. Miller, retired General Miller, because I'm not sure that we didn't enter those agreements. I don't recall, General Miller didn't recall, former General Miller, whether those were, as part of that, it was in lieu of a bond revocation. So I don't know. Add to that, I didn't know that we were going to get into all this stuff until 1:30 yesterday. I did not. Now, I don't know about that failure to appear, but I have not reviewed the conviction. I don't think General Bryson, I may have run through it. I was trying to run through this as quick as I could yesterday before I got out here, but that's not noticed, and it wasn't argued at the original hearing. So to come in and there's nothing sworn here other than things that has already happened. He did his time for those Sessions cases. The first two cases that are still before the court, I don't think those were bond on bond. They were presented, investigated, and directly presented at the same time, including the case that I'm asking to reinstate the bond on, which I would also add is the only case before the court. That's the case that the bond was revoked on. That's the case where I'm asking to have it reinstated. Mr. Godwin, as I said, has a newborn child. He'd be willing to yield to an ankle monitor or any other conditions that the court may impose. As I said, he has stayed in touch with me throughout the pendency of the case. He's not been proven a flight risk whatsoever. And I don't know if the court, General Bryson and I are more or less up here making arguments. And so, as I've argued before, the Bergens decision entitles you to cross-examination. And had that officer been here, I don't know that he could have identified Mr. Godwin in that case. It was a motorcycle that I don't think he could identify who it was on the motorcycle. So while some of these things that she mentioned were listed in the motion, they were never argued. He's never been able to cross-examine any of it. So, and I believe that maybe they did think this was going to go to trial when General Miller and I entered those convictions, but they didn't. And then a late filed notice of enhancement comes. This is not his. He carries the presumption of innocence on these cases that he's charged with. And I think he's entitled to bond. I don't think there's been a request in writing for the state to increase the bond, but he would yield to an ankle monitor. It would be no problem. So we're just asking that, and with respect to boobies, if they won't go back on the bond if they've been exonerated, the $10,000 bond would be fine. I could contact Ms. Sessler and see if she'd be willing to do that. But he would yield to any conditions. And if the court wants to hear testimony, we can do that. That's the reason I tried to reserve my objections so we can do this quickly. But I would object to the things that she entered as the court being entered as evidence. One, we weren't given those. I had no idea that that was going to be argued until yesterday at 1:30. So I object to them trying to go back and relitigate issues that weren't litigated at the prior hearing. Res judicata is one issue, and then the procedural due process violations.
All right, first and foremost, I would point out the following, and that is that the state's motion to revoke bond, which was filed February the 12th, 2024, was citing 4011-141, subsection B, and that statute says the following. If after the defendant is released upon personal recognizance, an unsecured personal appearance bond, or any other bond approved by the court, the defendant violates a condition of release, is charged with an offense committed during the defendant's release, or engages in conduct which results in obstruction of the orderly and expeditious progress of the trial or other proceeding, then the court may revoke and terminate the defendant's bond and order the defendant held without bail pending trial or without release during trial. That is the statute upon which the original motion was filed. I would simply point out it does not require that the defendant be convicted of an offense. It says where the defendant is charged with an offense committed during the defendant's release. So looking at the state's original motion revoke, in this court's opinion, my opinion was not based solely on one conviction or one charge in Lawrence County. That was the most minor of all of the charges, in my opinion. The state's motion revoke cites that he was originally, in this case that we're dealing with, charged with sexual battery and vandalism. Those happened on June 28, 2020. He was released on a $10,000 bond. While out on bond for that case, he was charged with rape that occurred on July 4th, 2020. That was after the date of the first case when he was released on bond. While out on bond for those two cases, he was charged in another case with vandalism that occurred on December the 1st, 2020, and that was a $50,000 bond. While out on bond for those three cases, he was charged with aggravated burglary and rape. Those offenses occurred on or about June 6, 2021. Again, he was released on $50,000 bond. While out on those cases, he was charged in Lawrence County and with driving on a suspended license, reckless endangerment, evading arrest. All of those were considered by this court in the original order revoking his bond in this particular case. The Lawrence County case may have been dismissed, but the reason it was dismissed, according to this court's review of the information, was because of the fact that the defendant, the defendant moved to suppress the evidence, and the court could not conduct an evidentiary hearing because the officer was, at that time, was deceased. So this court, in considering any bail motion, is not just required to consider the required to consider the charge itself, but is required to consider all of the factors that are set forth in 4011-118. And those factors set forth a number of different things, but one of the most significant is that the defendant's prior criminal record and the likelihood that because of the record, the defendant will pose a risk of danger to the community. And yes, the state has now filed a notice of enhancement and for impeachment, and the fact that the defendant was released on bail on this charge and has been charged in numerous other cases. And I don't dispute Mr. Spratt's argument that he is entitled to a presumption of innocence. But nonetheless, it is a factor that this court must consider, is that the fact that the defendant has a prior history and the fact that he was released on bail and committed these additional, or at least allegedly committed these others and was charged with it. And I would simply point out there's some case law that pretty well establishes that And this I'm citing from the State versus Mason, which is a Court of Criminal Appeals from 2016. And it is, the court states there that the trial court correctly revoked the defendant's bail based upon the need to protect the public safety after finding that the defendant had threatened others, including members of the district attorney's office, inquired about purchasing guns from a pawn shop and described as being vulgar and angry. Well, he was not convicted of those offenses in that case, but he was charged with, or at least there was evidence of that, of those threats being made. I am of the opinion that the fact that he was originally on bond in this case and was charged with not one but 2 counts of rape while being on bond for a sexual battery makes him a threat to the safety of this community, and therefore the court declines to reinstate his bond in this case and orders that all bonds that he has previously had in all cases are revoked. And he will be held pending the trial in all of those cases. That's the order of the court.
Your Honor, may I ask, I'll ask Madam Clerk, I'll be asking for the transcripts from that, Your Honor. Thank you,
That's
Judge.
fine.